Welcome back to the Deep Dive, where we take the most complex legal, financial, or technical documents and, well, we break them down into practical knowledge. If you've ever thought about preparing for the future, or, if you've ever been asked to manage the affairs of a loved one, you know the stakes are just incredibly high.
They really are.
Today, we are deep diving into arguably the most powerful document in personal planning, the New York Statutory Short Form Power of Attorney, or the POA.
And this is an incredibly focused deep dive. We are setting aside external case law. We're not speculating. Our mission today is really to understand the law's own explicit instruction manual.
So just the document itself.
Just the document. We are drawing exclusively from the mandated caution to the principle and the important information for the agent. I mean, these are sections that New York's General Obligations Law, Article 5, Title 15, actually requires to be printed right on the face of the form.
Wow. So they're not buried in the fine print.
Not at all. These sections tell you exactly what the state believes the risks are and what the responsibilities are.
We're looking at the built-in safeguards and, I guess, the giant red flags. What's so fascinating here is that the state doesn't just give you a form. It provides a contract summary and a warning label. It sort of assumes profound trust, but at the same time demands absolute legal adherence.
Right.
For you listening, this is really a shortcut to understanding why this document grants such immense financial authority and why the law imposes such specific, such strict rules for both sides of the coin. The person granting the power, the principal, and the person receiving it, the agent.
Well, you have to understand that the underlying tension of a power of attorney is immense. It's just huge.
How so?
You're granting one person near total access to another's entire financial life. And, it's often when the principal is at their most vulnerable.
Right.
So because of that sheer financial gravity, the law doesn't just assume good faith. It can't. It mandates structure, it mandates process, and it demands fierce accountability.
So we need to examine that fine print.
We have to. Because for an agent, violating these rules can lead to, just ruinous personal liability.
Okay, let's jump right in. Let's start with the principal's perspective. Before anyone even signs this document, they're required to read a section titled Caution to the Principal. So what is the truly shocking core message here? That the law wants to make sure no principal misunderstands. Okay, so let's unpack this. We're starting with the explicit warning given to the principal. And the language, it feels like it's designed to be blunt. Unavoidable, really.
It is.
The document states flat out that the principal gives the agent authority to spend the principal's money and to sell or dispose of property during the principal's lifetime. And here's the kicker. Without any obligation to inform the principal beforehand. That sounds terrifying in an age where money can move instantly.
It is absolutely terrifying.
Right.
And the law uses that bluntness on purpose, to really underscore the seriousness of the decision. When the source material calls this an important document, it's a huge understatement.
Right.
The authority is immediate, it's comprehensive, and crucially, it's unilateral. The agent can, if they choose to, access your bank accounts, sell your car, liquidate your investments, all without any required pre-notification.
So, okay, the absence of a required notification.
Yeah.
That's the point of greatest friction. But I'm guessing it's also the feature that makes the POA functional, right?
Exactly.
If the agent is trying to pull off some time-sensitive real estate closing or, execute a swift market trade for the principal, having to wait around for the principal's confirmation might just defeat the whole purpose.
Precisely. If you connect this to the bigger picture, the POA is primarily designed to function effectively when the principal cannot act quickly, or maybe can't act at all. Perhaps they're traveling or they're physically ill or experiencing cognitive decline. Requiring confirmation in those moments would render the document, pretty much useless in an emergency. But this necessity creates the enormous caveat. The validity of the whole arrangement rests entirely on absolute unwavering trust.
Trust. There's that word again.
The law mandates transparency after the fact, but it grants the agent operational autonomy before the fact. That's the necessary compromise.
And there's this worry that often comes up. A principal is worried that by signing the POA, they're somehow, signing away their own control.
Right, like they're giving up their own power.
Exactly. And the document has to clarify that's not what's happening. It's not a transfer of ownership or authority.
That's a vital point. The principal does not lose authority to act even after appointing an agent. They haven't transferred ownership. They haven't transferred control. They have simply duplicated access. This is the concept of concurrent authority.
Concurrent authority.
The principal maintains their authority to act on their own behalf, even though they've empowered their agent with, well, very similar authority.
I like to think of it as two keys to the same financial safe, held by two different people. Both keys work at all times.
That's a great analogy.
But what are the practical implications then, if both parties can act at the same time?
Well, it can create potential friction, especially with third parties, like a bank. For example, let's say the principal decides to transfer a large sum from account A to account B.
Okay.
And at the exact same time, the agent transfers that same sum of money to a totally different investment portfolio. The bank might suddenly be faced with two conflicting but both perfectly valid instructions.
So what happens?
The bank is generally protected if they honor the first instruction they received, but it illustrates how essential communication is, especially when the principal is still capable.
So the agent is meant to be a full power assistant, really.
Exactly. Acting collaboratively when the principal can, but, fully capable of acting independently when they can't. Okay,
so moving beyond just the raw power that's granted, the document has to address the fundamental requirement for how the agent must act. This is the best interest standard.
Yes.
The agent has to follow any specific instructions provided. But if there are no specific instructions, they have to act in the principal's best interest.
And this best interest rule, that is the overriding fiduciary duty. It is the legal standard that judges will apply when they're assessing an agent's conduct later on.
Let's expand on that. What does that actually mean in practice? Because it feels like the core legal firewall against abuse.
It is. So if the principal has written down very clear instructions, let's say, under no circumstances are you to sell my shares of XYZ Corporation, the agent has to obey that, period. Even if they personally think selling is a great financial move.
The instruction is absolute.
It is.
But what if the principal doesn't provide any specific instruction? Say, for a complex financial decision, like refinancing a property or making a large investment, how does the best interest rule guide the agent then?
The agent has to exercise prudence and, crucially, selflessness. The decision has to be objectively aimed at benefiting the principal and only the principal.
Can you give me an example?
Sure. Let's say the agent's own house is falling apart. They can't just decide it's in the principal's best interest to pay the agent some massive undeserved fee to manage a property, which then gives the agent funds for their renovation.
Right. That's obvious self-interest.
Obvious self-interest. A prudent action, on the other hand, might be something like liquidating a high-risk stock portfolio if the principal is now elderly and requires, guaranteed funds for long-term care. The action must be demonstrable as being financially sound for the principal's needs and goals.
So here's a question. If the agent is a financial professional, like a CPA or something, does the law assume a higher standard of care? Does that best interest standard get stricter based on their expertise?
That's an excellent question, and it really goes to the nuance of fiduciary duty. While the statute applies the same set of duties to every agent, if an agent has a higher level of expertise, like you said, a CPA or a licensed investment advisor, a court may very well judge their conduct against a standard expected of that profession.
So their own expertise works against them, in a way.
You could say that. A CPA agent who makes obvious accounting errors, for instance, might face a faster finding of breach of duty than, say, a relative with no financial background who just made a simple miscalculation. The expectation of prudence, it scales implicitly with the agent's claimed or inherent competence.
Okay, now let's talk logistics, activation and ongoing oversight. How does this relationship actually kick off, and what are the initial oversight mechanisms the principal still has?
The activation point is interesting. It's not the principal's signature, it's the agent's. The agent's authority only begins after they sign the power of attorney in front of a notary public.
So it's not just a formality?
No, not at all. That step is the agent's formal, legally documented acceptance of all the stringent liabilities and responsibilities we're talking about today. Until that signature is notarized, the agent has no power, and more importantly, no legal liability under the POA.
So the agent's notarized signature is like a formal declaration. It marks the start of their fiduciary commitment.
Exactly. And regarding ongoing oversight, even though the agent doesn't have to tell the principal before a transaction.
Which is the scary part we talked about.
Right. But the document guarantees the principal maintains the right to request information from the agent at any time. This is the principal's primary defense mechanism while they're still competent.
I see this as the constant audit threat.
That's a good way to put it.
The principal might not know what the agent is doing today, but they can demand to know everything the agent did yesterday, last week, or last year. What exactly should the principal be demanding in that case? Simple bank statements.
They should demand a full accounting, a record of all transactions, including receipts, and a ledger that shows not only the amount of the transaction, but its purpose. Remember, the agent is operating under that best interest standard.
So they have to justify everything.
They have to. If the principal requests the information, the agent must produce detailed records proving that every single expenditure and every investment was made to benefit the principal. If the agent starts stonewalling or, only gives vague summaries, that in itself could constitute a breach of duty and be grounds for revocation.
That's a really critical distinction.
Yeah.
The power is immediate, but the accountability is also immediate upon request.
Yeah.
Okay, let's move on to the hard boundaries of this authority. This is where it gets really interesting, because the law draws some very clear lines in the sand. The document is absolutely explicit about one major exclusion: healthcare. This financial POA cannot be used for healthcare decisions. A separate document, the healthcare proxy, is required for that purpose. Why did the New York legislature think this separation of powers was so critical?
Well, this is a fundamental legislative decision. It recognizes that financial authority and medical authority represent two entirely different dimensions of personal control. They're governed by completely separate legal frameworks.
Different laws for different powers.
Exactly. The financial POA deals with property, contracts, money. It's governed by the General Obligations Law. The healthcare proxy, that deals with life, death, consent, ethics, that's governed by the public health law.
So the law is basically forcing the principal to evaluate two different types of trust. The person you trust to manage your investment portfolio, they might have a really pragmatic, risk-tolerant approach. There's the exact opposite of what you'd want in an end-of-life care situation.
Precisely. By requiring two separate forms, the law ensures the principal intentionally appoints the right person for the right job, and it prevents the financial agent from having absolute control over the principal's entire existence.
So you could have two different people.
You could, and you often should have a different person as agent for finance and agent for healthcare. It ensures checks and balances. The law recognizes that a desire for financial gain or even just preservation of assets could improperly influence a medical decision if those powers were combined in one document.
Okay, let's move to revocation. The principal always has the power to end the agent's authority. But as you mentioned, it's not as simple as just, ripping up the paper.
No, it requires specific documented action.
And the rule is?
The principal can revoke or terminate the POA at any time for any reason, as long as they are of sound mind. That is the critical precondition. But the logistics of making that revocation legally effective, well, it requires a very proactive effort on the part of the principal.
The source says the revocation requires written notice, and not just to the prior agents, but crucially, to any third parties who may have acted on it. And it specifically mentions financial institutions, banks.
Yeah.
Why is that bank notification so important?
It's because of a legal principle called reliance. Until the bank or the brokerage firm or the title company receives that written official notice of revocation, they are legally protected in honoring the agent's transactions.
As long as they were acting in good faith.
Right, as long as they were acting in good faith based on the previous valid POA copy they had on file. If the principal just revoked the POA privately and the agent immediately went and drained the accounts using the old documentation, the bank is generally protected unless they were notified first.
So the revocation is only really effective when the institutions holding the assets are officially told.
Yes, usually via certified or registered mail. It prevents that liability gap. It places the burden on the principal to inform everyone who relies on the POA that they can no longer do so. If the principal is of sound mind, they're expected to manage that administrative burden to protect their own assets.
Which leads to the big complication. What happens if the principal is not of sound mind? I mean, this is often why the POA was created in the first place. What if the agent starts acting improperly once the principal becomes vulnerable and can't revoke the power themselves?
This is the moment the POA becomes a durable, protective instrument, but at the same time, potentially very dangerous. If the principal is no longer of sound mind, the source makes it clear that only a court has the power to remove an agent, and only if that agent is found to be acting improperly.
That sounds like a huge barrier.
Yeah.
It means that once incapacity is established, the principal isn't protected by their own judgment anymore, but by the legal system, which, moves slowly and requires a high standard of proof.
It does.
So what does a family member or a monitor, what do they need to prove to a court to get an agent removed in that scenario?
They need to prove a breach of the agent's fiduciary duty. This typically requires clear and convincing evidence, a very high standard, that the agent is engaging in self-dealing or commingling funds or making transactions that are demonstrably outside the principal's best interest.
So just making a bad investment isn't enough.
No, simple poor investment choices are usually not enough. The court has to see evidence of improper motive, often tied directly to the agent's own financial benefit. And this process, it requires petitioning the court, gathering detailed records of the agent's transactions, and proving financial malfeasance. It's expensive, it's time-consuming, and it puts the principal's assets at risk while the whole litigation proceeds.
It really highlights why that initial choice of agent has to be made with such intense scrutiny, because you have to know that once vulnerability sets in, the system is designed to protect the status quo, unless there's some kind of egregious wrongdoing.
Exactly. The durability of the POA, the fact that it survives incapacity, that's its greatest strength for long-term planning, but it also creates that window of risk for abuse.
And just to ground us again in this specific framework, the document itself gives the ultimate context for the governing law, which ensures total transparency.
Correct. The entire structure is governed by the New York General Obligations Law, specifically Article 5, Title 15. The document explicitly points out that the full text of this law is accessible online on the NY State Senate or Assembly websites.
So this isn't some obscure boilerplate.
Not at all. The state ensures that the law defining your rights and liabilities is publicly available. This transparency is a legal reminder that this document is not a suggestion, it is the law.
And that leads naturally to the final piece of advice right there on the form. The absolute need to seek legal counsel if any part of the document is misunderstood. I mean, if the state is telling you to hire a lawyer to understand the form they provided, the stakes have to be astronomical.
That is the system's final confession of complexity, in a way. The complexity of fiduciary duty, the gravity of the financial powers, and the strict adherence to the law. It all means that if the principal or the agent has any doubt about what they're doing, they must consult a lawyer. It's an acknowledgement that the ramifications of signing this document are far-reaching and, well, potentially catastrophic if mismanaged.
Understood. So we've established the warnings for the person granting the power. Now let's shift gears completely and look at the person taking on this monumental task. The agent, and the 5 non-negotiable duties they agree to uphold. Okay, shifting focus entirely to the agent. When they accept this role, the document says they enter a special legal relationship. That phrasing, special legal relationship, it sounds really intense. What does that signify beyond, a simple handshake agreement?
It signifies that the responsibilities are not merely moral or familial or just a favor. They are legal and fiduciary.
Okay.
This means the agent must act with the highest standard of care and loyalty known in the law. They legally must place the principal's interests above their own at all times. The document explicitly warns that these responsibilities continue until the agent resigns or the POA is terminated or revoked.
So it's a formal, high-stakes legal commitment.
It is. You can't just walk away because you got too busy. You have to follow a formal, documented process to get out of it.
And the statute defines exactly what this special relationship requires by laying out 5 non-negotiable duties. Let's break these down because this seems like the agent's operational legal checklist.
It is, starting with Duty 1, adherence to instructions' best interest. This just reiterates that primary requirement. Follow the principal's instructions if they exist, or if they don't, act in the principal's best interest. It's the golden rule, really. It makes the agent's discretion always bounded by what benefits the principal financially, never the agent's convenience or personal gain.
Then Duty 2 addresses what seems like the inherent ethical and psychological challenge of the role, conflict avoidance. The agent must actively avoid conflicts that would impair your ability to act in the principal's best interest.
And this is where most agents stumble, and often it's inadvertent. A conflict of interest exists whenever the agent has some personal motive that might sway their decision for the principal.
Can we walk through an example?
Of course. Let's imagine a scenario. The principal owns a piece of land, and the agent knows it's going to be valuable soon. But the agent's own real estate company would profit handsomely from managing the sale right now.
Okay.
Even if the agent believes the sale is reasonable, using their own company to execute the deal creates a conflict. Their judgment is biased by their own potential profit margin. The duty requires the agent to step back from situations where their objectivity could even appear to be compromised. They have to act impartially, as if they were a dispassionate third-party advisor.
That seems incredibly difficult to maintain, especially in a family setting. It's not just about avoiding outright self-dealing. It's about maintaining unimpaired objectivity in every single decision.
Absolutely. The law looks at intent, but judges often look at appearances. The moment an agent benefits, or a close family member of the agent benefits from a transaction, that action is automatically suspect. And the burden of proof shifts heavily onto the agent to prove that the decision was necessary and prudent for the principal.
Wow. Okay, duty 3 is perhaps the most important logistical rule for preventing theft or even accidental fraud: segregation of property. The agent must keep the principal's property separate and distinct from any assets the agent owns or controls.
This is the strict prohibition against commingling funds. You cannot, under any circumstances, place the principal's money into your personal checking account.
Not even for a minute.
Not even if it's just for a moment or to pay a bill online quickly. The legal distinction between the principal's assets and the agent's assets has to be maintained perfectly, permanently.
Why is the law so obsessively strict about that separation? I mean, if the agent has access and they plan to pay it right back, why is a moment of commingling so legally toxic?
It's because mixing funds completely destroys the paper trail, and it exposes the principal's assets to the agent's personal liabilities. Imagine the agent accidentally commingles funds, and then, totally unrelated to the POA, the agent faces some personal financial distress, a lawsuit, a sudden debt, a divorce.
I see where this is going.
If the principal's money is sitting in the agent's personal commingled account, those funds become legally accessible to the agent's personal creditors. Or they become contested property in a divorce proceeding. The principal's ownership is completely obscured. Strict segregation is the bedrock of accountability, and it protects the principal from external risk.
That's a powerful incentive for the agent to maintain separate accounts. Moving on to duty 4, record keeping. The agent must keep a record of all transactions or keep all receipts of payments and transactions. This seems crucial for accountability.
It is, and in the modern context, this means the agent needs an organized, systematic ledger. This isn't just about keeping a shoebox full of receipts. Given the expectation of audits by the principal, or more seriously by a court, the agent must be able to account for every dollar spent, transferred, or invested, along with the purpose of that transaction.
What kind of level of detail are we talking about, beyond just the numbers?
They need to document prudence. If they liquidate a large asset, they should keep market research or quotes that demonstrate they got a fair price. If they pay a service provider, they need the invoice and the canceled check or the transaction record. If they make a large discretionary payment, they should keep a written note explaining why they believed this action was in the principal's best interest at that specific time.
So good record keeping is the agent's best defense.
It is their absolute best self-defense mechanism against any future claims of malfeasance. If you can't prove the transaction was for the principal, the law will pretty much assume it was for you.
And finally, duty 5 deals with disclosure and the public face of the agent's action. Disclosure of identity or the signing rule. When acting for the principal, the agent must disclose their identity in writing. And the source even provides the 2 specific, legally defined methods for signing.
This duty is non-negotiable for interacting with banks, real estate agents, any government entities. The third party has to know that the person signing is acting under delegated authority, not as the owner of the assets.
And the 2 required formats are?
They ensure legal clarity. The first is principal's name by your signature as agent. The second is your signature as agent for principal's name.
What happens if an agent just signs their own name without that as agent designation? Does that jeopardize the transaction, or does it put liability on the agent?
It does both. If an agent signs a contract simply with their own name, they risk being held personally liable for that transaction because they failed to properly exercise their delegated authority, which requires that clear disclosure.
And the third party.
Furthermore, the entity receiving that signature might legally challenge the transaction, claiming the agent failed to properly identify their role. This tiny detail, the as agent designation, is the legal bridge that connects the agent's action back to the principal's authority. Ignoring it means the agent is operating without proper legal coverage.
Those 5 duties combined, they really form a rigorous legal cage that the agent has to operate within. Now, let's look at the absolute restrictions and what happens when an agent fails to comply. So let's look at the absolute line the law draws: self-dealing and gifting. The rule laid out in the document is, well, it's strict and it's unwavering. The agent may not use the principal's assets to benefit themselves or anyone else, or make gifts to themselves or anyone else.
This is the most stringent safeguard in the entire document. It means the principal's assets are purely for the principal's maintenance, support, and financial growth.
So no gray area.
None. The agent cannot grant themselves a salary unless it's explicitly authorized. They can't pay off their credit card debt. They can't buy a birthday gift for their neighbor using the principal's money. The agent is a caretaker of the finances, full stop. They are not a beneficiary in any way.
But the statute has to acknowledge that in estate planning, a principal might want the agent to have gifting power, maybe for tax purposes or continuing a pattern of annual giving. How does the law accommodate that while still maintaining the prohibition?
It creates a very narrowly defined safety valve. The only exception is if that specific authority, to benefit themselves or make gifts, is granted explicitly in the modifications section of the document. Typically, this is done by initialing specific boxes on the form.
So it has to be a conscious choice.
Exactly. It ensures the principal consciously and intentionally waived the standard prohibition. If those boxes are left blank, the prohibition is absolute.
And even if gifting authority is granted, there is that crucial subclause. The agent is still bound by the instructions, or, lacking instructions, the principal's best interest.
That's the double lock. Gifting authority is not a free-for-all. Say the principal is in a nursing home and requires constant care, and they're rapidly depleting their funds.
Okay.
Even if the agent has the authority on the gifting box checked, they cannot rationally claim it's in the principal's best interest to give $10,000 to the agent's own spouse. The fiduciary duty always overrides the discretionary power, especially when the principal's core needs are at risk.
They'd have to prove the gift was reasonable.
They'd have to prove the gift was aligned with the principal's established pattern, their goals, and that the principal could actually afford it.
Okay, let's talk about how an agent can formally get out of this special legal relationship. Since it's a formal commitment, I assume the resignation process also has to be formal.
It must be. It has to be done via written notice. This written notice formalizes the end of the legal duty, and crucially, it has to be provided to a wide range of parties to ensure continuity.
So not just the principal.
No. That notice goes to the principal, of course, but also to any co-agent, any successor agent, a named monitor, if one exists in the document, or the principal's appointed guardian.
That list of recipients, that ensures that if the principal is incapacitated, someone else is immediately aware that the financial management is now, well, unstaffed. It prevents a management vacuum.
Exactly. It prevents a scenario where the agent just quits without telling anyone, leaving the principal's affairs completely exposed. And the agent's duty to account for all their transactions, that doesn't end with resignation. They must still prepare and provide a final accounting.
Now, let's get to the serious nature of agent liability. The law explicitly warns that if the agent violates the New York General Obligations Law, Article 49, Title 15, or acts outside the authority they were granted, they may be liable under the law for that violation.
The term may be liable is a clear legal threat. It means the agent can be held personally and financially responsible for any financial loss the principal suffered because of the agent's improper actions.
Personally and financially responsible.
Yes. If an agent commingles funds, and those funds are lost in the agent's personal bankruptcy, the principal or the successor agent can sue the agent to recover that money from the agent's remaining personal assets.
So the liability isn't just abstract, it's a personal financial threat. It requires the agent to potentially repay misspent funds out of their own pocket. And they could potentially face criminal charges if willful theft or fraud is proven.
That's absolutely correct. This legal threat reinforces the idea that the agent is not merely performing a favor, they are entering a legal role with severe consequences for negligence or misconduct. The principal's interests are legally protected by the agent's personal liability.
So, synthesizing this for our listener, we see that the agent is essentially stepping into the principal's financial shoes. But they're under this intense legal scrutiny with specific rules designed to protect the principal from information asymmetry and financial abuse.
That's the perfect summary. The entire section, Important Information for the Agent, is a detailed declaration of fiduciary standards. It confirms that the system understands the vulnerability inherent in granting this kind of power, and it protects that vulnerability through mandatory strict rules for record keeping and separation, which re-emphasizes the document's closing advice: seek legal advice if the agent's responsibilities are unclear.
Because if the agent proceeds without fully grasping the segregation rule or the conflict avoidance duty.
They are placing themselves and the principal at severe legal risk.
This deep dive really emphasizes that the NYPOA is not a simple form. It's a rigorous legal instrument that demands legal professionalism from a potentially amateur agent. So, let's bring it all home. This deep dive shows that the New York Power of Attorney is a detailed contract creating a rigorous fiduciary relationship. It's defined by these specific requirements for record keeping, property separation, and conflict avoidance. The state is essentially saying, we trust you enough to delegate immediate power, but only if you adhere to these 5 duties and the absolute prohibition on self-dealing.
And if we connect this to the bigger picture, so what does this all mean? The fact that the New York statute requires this level of detail and caution right on the face of the document, it really reveals the greatest risk in a POA. And the risk is not the legal scope of the power itself, it's the human factor.
The failure of the agent.
The failure of the agent to strictly adhere to the defined legal relationship. When an agent fails to strictly separate assets, or fails to meticulously document every single transaction, proving they met that best interest standard becomes nearly impossible. And that leads directly to the liability the statute warns about.
That's a powerful point. The law assumes good faith, but it mandates the ethical infrastructure to prove it later. And that brings us to our final provocative thought for you, the listener, to mull over. Considering the strict liability and the mandate to avoid conflicts, how might an agent demonstrate definitively to a court or to the principal that every decision they made, especially ones that might seem questionable after the fact, truly met that subjective best interest standard? If an agent makes a major investment decision, what kind of documentation beyond simple receipts would be necessary? Maybe detailed minutes of meetings, records of legal consultation, or comprehensive market research to prove intent and prudence long after the decision was made.
It's a challenge of proving pure intent in a world of financial scrutiny. Something to think about when you consider who holds your keys. Thanks for joining us for this deep dive into the legal complexities that underlie trust.
We'll see you next time.